The main theme of my talk to you guys today, and ladies, is the necessity for us as financial service professionals to collaborate to serve our clients best and really achieve their goals. Let's talk about some of our clients' goals. They have wealth building goals, wealth retention goals, and wealth transfer goals. Within each of those goals are smaller goals. So the financial planners and you guys as agents and life insurance agents, y'all are skilled and trained in building wealth for your clients. The other thing that you do is transfer that wealth to future generations for your clients. That's what I do as well. I am on the wealth transfer side of fulfilling that need for the client. So the lawyer and the planners and agents are involved in wealth transfer, and then we have the CPAs that get involved for wealth retention. Let's not let the tax man get our money and what we've worked for. Some other goals that our clients have, especially in my area, is not just wealth transfer, but specific distribution provisions to care for minor children if the parents die while their children are minors, or to provide for a surviving spouse. So we also have those goals of our clients to consider. The only way we can achieve all of those goals for our clients as financial service professionals is to collaborate. What I am going to talk to you about is what a good estate planning lawyer can bring to the table and how that can help you fill all of the goals for your clients and not just the one goal that you're looking at for them. Why do your clients need a will? A will is simply no more than a disposition of property to take effect at the time of death. Your clients need a will, absolutely, because dying without a will in the state of Texas, the rules of descent and distribution set forth in the probate code are going to govern who gets their money. And it sometimes can lead to quite surprising results for clients that they are completely unaware of and did not anticipate. So, for example, in the state of Texas, if a husband has separate property real estate that maybe he inherited from his family members or maybe his mom and dad, that's considered separate property in the state of Texas. And separate property real estate, the surviving spouse only gets a 1/3 life estate in that property. For June and Ward Cleaver, that is not the desired result. Typically, a spouse that's been married for a long time, they're going to want their spouse to inherit that property, not necessarily children. So that is a surprising result to clients and is an absolute classic example of a failed financial goal for them. Another reason your clients need to have a will is minors are not allowed to inherit money. If you have children that are minors and you die without setting up a trust in your will, that money is going to be paid to the court registry until a judge can set up either a court sanctioned or court ordered trust for those children that is going to be governed by statute, not your client, or a lengthy and cumbersome guardianship proceeding is going to have to ensue in order to take care of those funds. So now you know why your client needs a will. Let's talk about what makes a good will. And before we do that, we're going to talk about some statutory requirements. Sometimes your clients might ask you, well, you've said I need to go get a will, but can I just do it myself? Can I just print one off the internet? No, and here's why. There are some key statutory provisions for a will. It has to identify the testator. It has to be signed with testamentary intent, and it has to have been signed with testamentary capacity. So the person making the will has to fulfill some of the statutory regulations for who can make a will. And only an attorney can advise a client on that. The will also has to be executed with a certain number of execution formalities. And if there is an attorney that's not overseeing that step, or if the client decides to do that on their own, there's a high risk that those execution formalities are not going to be carried out correctly, resulting in failed goals. The will's not going to work for them. Your clients might also ask you about changes in a will. If I just want to make one change to a distribution provision, can I just handwrite it on the side and kind of initial it and date it? And the answer in Texas is no. Changing your will by any handwriting or typing it on there will not be effective upon your death. You actually have to do a codicil or a completely new will.